Prior to the Declaration of Independence being adopted, Virginia adopted their Declaration of Rights. A Declaration of Rights is made by the representatives of the good people of Virginia assembled in full and free convention, which rights do pertain to them and their posterity as the basis and foundation of government. George Mason wrote this declaration, but its impact goes far beyond the Commonwealth of Virginia. We can see the influence of this document on Thomas Jefferson in the opening paragraphs of the Declaration of Independence. We also see it in our Bill of Rights. So let's take some time and look at this predecessor of our Declaration of Independence. Next on the Constitution Study. Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution and, by the way, some other documents. We teach the rising generation to be free. I'm glad you could join me. Sometimes in my studies, I come across a document that it catches my attention. I hadn't studied it before. It moves me. It grabs me, and this is one of them. I'd never studied the Virginia Declaration of Rights before, but I'm learning so much from it, so I wanted you to join me here. Now, if you want to ask some questions or find out more, you can always do so at the website, constitutionstudy.com, but I'll talk more about that site and other ways you can engage at the end of the episode. For now, let's take a look at the Virginia Declaration of Rights. The Virginia Declaration of Rights is broken down into 16 sections. Today, we'll look at the first 8. Now, Section 1 reads, that all men are by nature equally free and independent and have certain inherent rights of which, when they enter into a state of society, they cannot, by any compact, deprive or divest their posterity, namely the enjoyment of life and liberty, with the means of acquiring and possessing property and pursuing and obtaining happiness and safety. We find a similar theme in the second paragraph of the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Our freedom and independence does not come from government. It's something we have by our nature, along with certain inherent and unalienable rights. When we join together in a society, we do not give up those rights. While both Jefferson and Mason agreed on life, liberty, and the pursuit of happiness, Mason included the acquisition and possession of property, something that would be protected in the Fifth Amendment to the Constitution of the United States. Section 2. That all power is vested in and consequently derived from the people. The magistrates and their trustees and servants are at all times amenable to them. One of the things in the constitutions of most of the states, but not in the Constitution of the United States, is this statement that all power is inherent in the people. George Mason recognized that all power is vested, encompassed in the people. But we also notice that magistrates, those who hold office, are trustees and servants of the people. That means anyone who works for a government, whether elected, appointed, or employed, is working for the people. Section 3. That government is or ought to be instituted for the common benefit, protection, and security of the people, nation, or community, of all various modes and forms of government, that is best which is capable of producing the greatest degree of happiness and safety, and is most effectually secured against the dangers of maladministration. And that, when any government shall be found inadequate or contrary to these purposes, a majority of the community has an indubitable, inalienable, and indefeasible right to reform, alter, or abolish it, in such manner as shall be judged most conducive to the public weal. Again, we see the influence George Mason had on Thomas Jefferson in writing the Declaration of Independence. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such a form as to them shall most likely to affect their safety and happiness. Government is created for the benefit of the people, to protect their rights, and for their protection and security. The very purpose of government is to serve the people, a concept that seems to have been lost in modern America. Now, since governments are created to serve the people, if a government is unable or unwilling to do so, then it is the right of the people to alter or abolish it. Section 4. That no man or set of men is entitled to exclusive or separate emoluments or privileges from the community, but in consideration of public services, which, nor being discernible, neither ought the office of magistrate, legislator, or judge to be hereditary. No one is entitled to emoluments, profit, or privileges from the community except as compensation for public service. What does that say about government entitlement programs? If the people are not entitled to government monies except as payment for public services, then America's entire welfare state is a fraud. Notice, it's not just money that people don't have a right to demand from the community, but privileges. Also, in America, we do not have hereditary offices. As much as it may seem that some families have an almost exclusive right to an office, that's more a factor of the people's sentiment than the law. Section 5. That the legislative and executive powers of the state should be separate and distinct from the judiciary, and that the members of the first two may be restrained from oppression by feeling and participating the burdens of the people. They should, at fixed periods, be reduced to a private station, returned to that body from which they were originally taken, and the vacancies be supplied by frequent, certain, and regular elections in which all or any part of the former members to be again eligible or ineligible as the law shall direct. Here we see the idea of separation of powers in government. Well, not necessarily the full three branches of government we're used to. So George Mason called for the judicial power to be separate in order to act as a check on the legislative and executive branch. He also calls for the legislative and executive branches to be chosen by regular election. A lot of people complain about how the political class seems to make a career of elected office, but they forget that if a majority of those voting choose to return them to office, that's their decision. I agree we'd be better off if those elected to office return to the real world every so often. All we have to do is convince a majority of our neighbors of that as well. Section 6. The elections of members to serve as representatives of the people in assembly ought to be free, and that all men having sufficient evidence of permanent common interest with and attachment to the community have the right of suffrage and cannot be taxed or deprived of their property for public uses without their own consent or that of their representatives so elected, nor bound by any law to which they have not in like manner assented for the public good. I'm pretty sure most Americans want their elections to be free and that everyone who can legally vote is allowed to. But George Mason had an interesting requirement for voting: evidence of a permanent interest and attachment to the community. Now, for those jurisdictions attempting to prevent the use of photo identification and allowing non-citizens to vote, I point to this expectation. We also see the idea of private property not being taken for public use without the consent of the owner or their representatives. This is similar to the Fifth Amendment's taking clause, which requires any taking of private property for public use to be justly compensated. George Mason also noted, we are not to be bound by any law that have not been created either by our own consent or by our representatives. Think about that in our current bureaucratic administrative state, the number of administrative laws coming out of the executive branch of the federal government. Section 7. That all power of suspending laws or the execution of laws by any authority without consent of the representatives of the people is injurious to their rights and ought not to be exercised. Based on this, the idea of a court suspending laws without the consent of our representatives in the legislature is a violation of our rights. This is certainly something worth thinking about at the federal level. Perhaps that is why this power was never delegated to the judicial branch in the Constitution. Then again, since those in Congress and most of our state legislatures ignore the Constitution already, it's kind of a catch-22. And lastly for today, Section 8. That in all capital or criminal prosecutions, a man has a right to demand the cause and nature of his accusation, to be confronted with the accuser and witnesses, to call for evidence in his favor, and to a speedy trial by an impartial jury of 12 men of his vicinage, without whose unanimous consent he cannot be found guilty, nor can he be compelled to give evidence against himself, that no man be deprived of his liberty except by the law of the land or the judgment of his peers. We see much of this in the Fifth and Sixth Amendments' protections of the accused. Of course, the Constitution of the United States doesn't state that a jury must be of 12 people or the requirement of a unanimous consent to guilt. Those are part of our statutory laws. Now, we are now halfway through the Virginia Declaration of Rights. We've seen what I believe is not only the predecessor to the Declaration of Independence and the Bill of Rights, but the basis for much of what is included in them. This is why I think this document is worth studying. If we want to know how we got here, we need to understand where we started. If we wish to correct the mistakes of our past, we need to look at where we started to know where we went wrong. Now, as we proceed to the second half of this declaration, I believe we'll not only learn more about our founding, but also the principles of the man who wrote it. So there we go, the first half of Virginia's Declaration of Rights. I hope you found this interesting. I find those parallels very engaging, very enlightening, very much understanding some of the other people's thoughts to Jefferson's words in the Declaration, and understanding that George Mason had a lot of influence in the Bill of Rights as well probably helps. Now, I will do the second half next week, but until then, by all means, head to the website, constitutionstudy.com. Let's start a discussion about this. Ask questions. Let's get engaged. I have a website called constitutionscholars.com. That'd be a great place to join, which you can do absolutely free. And let's start a discussion. Let's understand the history behind our declaration and maybe educate a few of ourselves and our neighbors about some things we weren't aware of. Let's take these ideas from the Declaration and see if we can't expand them into understanding what our founding fathers were thinking of when they wrote those documents. The only way we do that is with a little bit of study. Now, hopefully you enjoyed this. Hopefully you'll share this with others. And hopefully you'll bring them along next time when we meet for the Constitution study.